Good afternoon, everyone, and welcome back to the first episode of Digital Law News in 2021. So I'm joined today with my colleague Peter, and we are both here on behalf of Digital Law UK. So Digital Law, for those who don't know, who haven't listened to our podcast before, is a small, a niche law firm based in Barnsley, and we specialise in data protection law, cybersecurity, and law based on technology. So I'll just pass over to Peter to give himself a little introduction.
Thank you, Laura, and yes, hello everyone, and Happy New Year. No, you haven't missed any episodes. We've just taken a bit of a break over the Christmas and New Year period. I think it's safe to say nothing's really happened much, really, Laura, has it? It's been really quiet overall.
Yeah, definitely.
So yeah, we've actually got some really big stories to discuss, everything from Brexit and WhatsApp through to some pretty big stories also related to pandemic issues as well. So without any further ado, we'll crack on.
Yeah, absolutely. So the first story today is in regards to Brexit. So as everyone has probably heard in the news, a trade deal was agreed. But now this is having implications on the delays of things getting sorted in terms of data and the transfer of that. So like I've said, a deal has been agreed. However, there is no news in regards to an adequacy decision as yet. And due to this, the transition arrangement that has currently been in place over the last couple of months before the trade was agreed and we actually officially left the EU, this transition period has actually been extended for another 4 months in the hope of trying to get an adequate decision through and other things in place so that personal data can be transferred as it has been for the last God knows how many years.
Indeed, thanks, Laura. I mean, I think in many ways the fact that the transition period has been extended as far as data transfer is concerned is a good thing, because now it means that we've got this extra 4-month window through to, of course, the end of April, and that means that now is sort of the D-Day very much for data transfer with regards to Europe and the UK. And that means that whereas all the publicity in December was about if you were exporting goods to the EU, and it was very much, I think a lot of businesses thought, well, you know, we don't send containers full of goods to Europe, or we don't have a big supply chain reliance on Europe. I think a lot of businesses thought, well, it doesn't apply to us, we don't have to worry. When, of course, a huge amount of organizations do rely on having their data stored in Europe. Don't forget, this doesn't mean just continental Europe, because an awful lot of the servers, for everything from AWS to Microsoft Office 365 through to Facebook, Twitter, Amazon, the whole lot is stored, and certainly their European operations are stored in Ireland. And of course, Ireland is an EU member state. So this has huge implications with regards to cloud storage, as well as the transfer and receipt of personal data from countries outside of the UK into the UK from Europe. And we've now got this extra 4 months, but I would not make the mistake of presuming that we will get an adequacy decision come the end of April. And there's several reasons for that. We've talked in the past about the high levels of surveillance that take place in the UK, which in many ways are comparable with the surveillance regime in the United States. And because of the US surveillance, that's meant the US has never had a adequacy decision from Europe, whereas Europe has given adequacy decisions to countries like New Zealand and Japan and Canada. And there's the fact there have been other recent decisions in the European Court of Justice with regards to data adequacy, and in particular the way that data is handled in the UK, that give pause for thought. And there is also the fact that there is a certain lack of goodwill now on both sides, because while the free trade deal, well, I say free trade deal, but if you speak to many hauliers, they're saying, well, look, there's actually quite a bit of red tape. It may be tariff-free access, but it doesn't mean it's red tape-free access between the UK and the EU. It also means that, you know, that there's a dispute taking place even down to the UK failing to recognise the EU's ambassador, who's turned up in London saying, hello, I'm your EU ambassador. I'd like to present my credentials to the Queen to be formally acknowledged as an ambassador, and the government in London is saying, well, the last time we looked, the EU wasn't a country, so no, we aren't going to give you access, even though there are EU ambassadors in over 100 countries all around the world. But it is a big point for the EU. You know, are you a country or not? Arguably, if the EU is a country, then why do we have ambassadors from France and Germany as well? So you know, it's actually the British government giving the EU a stress test. But there have also been problems with everything from lorry drivers having their ham sandwiches confiscated when they've arrived in the Netherlands, and various examples of petty officialdom on both sides. And I don't think at the moment there is much goodwill. Having said that, the City is pushing for a memorandum of understanding with regards to the appliance when it comes to financial services, and that may mean that data adequacy could end up being packaged in with that memorandum, because it's around regulatory standards and recognition of regulatory standards. So who knows, this could happen, but I wouldn't put money on it. And I keep just saying to people, use these 4 months to consider if you're, well, we're talking about data transfers here with a third party, then make sure you've got a good data sharing agreement in place, and make sure that you are sharing that data with standard contractual clauses present in the contract, because at least then you can fall back on that arrangement. There are other options available, binding corporate rules if you're in one big organisation, codes of conduct potentially as well, but now is the time to make sure and mitigate and make sure you've got a plan in place. Hope for the best, plan for the worst.
Yeah, absolutely. And I know you, Peter, actually featured in a webinar last week with the Law Society, and you've been posting that on our social media. And we're actually going to include the link to that webinar as well on our website as well when we put the podcast up down there for the recording. Peter does go into more depth about that, about the implications the trade deal has had and what is kind of expected now as well. So we'll make sure that the links to that are in the description of this podcast. So staying on the data front then, so the next story is in regards to WhatsApp and their change of terms. So I think a lot of us know now that WhatsApp is now owned by Facebook, and over the past few years when WhatsApp has been owned by Facebook, they've kind of tried to keep the two entities separate. However, now WhatsApp is kind of forcing its users to agree to the sharing of information with Facebook if they want to continue using this service. So the only thing that they have said is that European and UK users will not see the difference, these sharing differences, although they will have to accept the new terms. So basically companies are now being warned that in this pop-up, when they are using the app on WhatsApp, you'll kind of get a pop-up and say you need to accept these new updates to continue using WhatsApp. And if you don't accept these new terms, then it's basically delete the app.
Indeed, thanks, Laura. I mean, this has massive implications for the use of the WhatsApp platform. I think the important thing to bear in mind is that when WhatsApp was taken over by Facebook, almost 10 years ago now, then there were covenants at the time that said that WhatsApp will be preserved as a sort of corporation in its own right, and there was only a fairly minimal amount of sharing of data between WhatsApp and Facebook as its parent company. But it looks like the sort of covenants and agreements made at that time are now expiring. So Facebook is looking to consolidate the interests and the data that it has within WhatsApp and to align it more closely with the parent company. Of course, Facebook now has 3 billion active users, and they're looking to, in effect, sort of monetize the data that is held within WhatsApp. And that means that, you know, famously, Facebook ends up using fairly aggressive methods, even just on its Facebook apps, to look at, you know, if you've got a Facebook app on your mobile phone, it's not just being used for Facebook. That app is also looking at everything from data related to your phone calls to your text messages, not Facebook Messenger messages, your text messages, as well as it'll be utilizing GPS data on the phone. It'll be looking at all the masts that device connects to. It's a really invasive app. And the point here, I think, is that WhatsApp's terms are changing to show that, look, those same invasive practices that are accepted practice on Facebook will now be applying to WhatsApp, and there will be cross-pollination of data. and in effect, it's just bringing it into line with what Facebook already does. Now, I've had a few people get in touch with me and say, oh, does this mean we should stop using WhatsApp? And I tend to say, look, if you're already using Facebook and you use WhatsApp, it doesn't really make an awful lot of difference. You shouldn't be using WhatsApp for business purposes, I hasten to add, because it is arguably it wasn't suitable previously. It certainly isn't after this change of terms of service. So if you are using it for your business to speak to your customers, I would quickly stop doing that and actually find a premium alternative network to use, or a better system of instant messaging you can use. And I wouldn't even use WhatsApp internally. So if you've got like an internal WhatsApp group for your team so that you can stay in touch, or across your firm, your organization, I would find an alternative, because it is simply the case that your conversations and discussions on that are not secure. And if you are a business in a related entity, like, for example, a law firm like us, or say an accountant, or you're in financial services, or even say if, you know, say you're involved in the current response to the pandemic and you're working in the NHS or an agency involved in dealing with the vaccine or testing and tracing, anything like that that involves personal data and is highly regulated, you really shouldn't be using WhatsApp or going anywhere near it anyway. And I certainly wouldn't be using it now that these terms have changed. So it's really just a sort of a bit of a wake-up call to realise, look, WhatsApp is not a secure product. But I think the other thing to bear in mind is that apparently other alternative platforms like Telegram have picked up tens of millions of users from people going, oh, we don't want to use WhatsApp anymore, it's not secure, we'll go and use Telegram. And I hate to break it to you, but Telegram is no better. There are significant problems with Telegram with regards to it potentially being used by other parties, potentially being used by the Russian state. It is by no means a secure platform either. I would be very skeptical of any free online messaging platforms. As I say, if you are business, I would look at using a premium service. But as I say, if you're just communicating with friends and family and it's just fairly vanilla stuff, fine. I just wouldn't be putting information on there like my bank account information or any important personal information like that. But just for generic, hi, you know, staying in touch with people. Hi, how are you? How are you enjoying being locked in your house? You know, that sort of stuff. It's not too much of a problem. But anything anything less benign than that, then I'd look at just not using WhatsApp or Facebook for that matter.
Yeah, absolutely. I think the key thing is when you're looking to use one of these instant messaging apps, just make sure it is a premium service and make sure you do your research before. Look into the security they have on the system and things like that. All that information, if they are a secure service, that information should be freely available on the site. So, yeah.
That's exactly right, Laura. And also, it's just a matter of asking those questions, like you say. Is it doing the research? Is it secure? Where is the data stored? Where is the data backed up to? What's the encryption standard? How do you export some of the chats that you might have on there to other platforms? Because that's sometimes an indicator of a lack of security. If it comes up with a list of platforms as long as your arm that you can export your data to, that might suggest it's not necessarily the world's most secure platform. So it's just a matter of really thinking about what you're using these things for and acting accordingly.
Absolutely. So moving on to the next story then. So this is regards to a motor industry employee who has been sentenced and has now been prosecuted under the Computers Misuse Act, and they've been prosecuted by the ICO. So an employee who actually worked for the RAC has been sentenced to 8 months imprisonment and suspended for 2 years, which was in a prosecution which was brought by the ICO. So in this, she actually transferred the personal data of people who were involved in road traffic accidents to a claims management firm without the authorization of her employees. So she compiled a list of different road traffic accidents data. So this included partial names, mobile numbers and registration numbers of cars, and then sent this list to the claims management firm without her employees' authorization, or basically without any cause to do so.
Yeah, I mean, this is quite a fundamental issue, isn't it, Laura, with regards to use of data here? It's not just the fact that they took personal data from those involved in accidents who are RAC members and would probably have received information relating to, call outs and the problem and everything related to vehicle data and where they lived and where they were recovered from. It's also the fact that not only are you taking that very sensitive data, but then selling it for your own fun and profit is a fairly big no-no by any measure. And in this instance, it's just showing that selling that information on to a claims management company is simply not acceptable. I think this person has been very fortunate that the sentence has been so light, to be perfectly honest. 8 months suspended for 2 years. I mean, you'd hope that they aren't going to do it again and won't be in a position to do it again. So hopefully that isn't going to go from being a suspended sentence. But it is a reminder that data you come across when you are an employee belongs to your employer and should not be exported for your own use. And I think it's also important to remind ourselves of the fact that if you are in a significant, if you're in a regulated entity as well, like a law firm, an accountant, medical practice, yeah, that data is the sort of stuff that should be secure under lock and key as well. And let's remind ourselves of the fact that a solicitor was struck off last year for sending a document that they thought was just a precedent. It turned out to contain personal data related to a client, and they sent it to their own personal email address, and that was enough for them to be struck off. So it's a matter of remembering that if it's business information, it stays on a business network. You shouldn't be exporting it to your own email account or your own WhatsApp or your own cloud system so you can work on it at home. That is not on. When you are, for example, working from home, you continue to use all of the business systems that have been provided for you, and you shouldn't be using your own personal systems, personal email, personal cloud, etc. Because as we can see through this, you're then playing with fire in terms of the Computer Misuse Act or potentially other regulatory action, depending on the sector that you are employed in.
Yeah, absolutely. I think this is just the important one that we needed to mention, because we don't really see cases like this. It's always the company being fined or prosecuted for some reason, but now it's just clear that this does happen. It's rare, but it still does.
Indeed, and it's also remembering that usually with the ICO, of course, they do enforcement, and like you say, it's a business that they go after, and it's a fine. So that business is looking at millions of pounds under GDPR. This is a prosecution, so that's what I say. Lucky in this, could have ended up in prison.
Yeah.
And it's still a conviction and a criminal record, of course.
Yeah, of course. So moving on to the next one then. So this is quite an interesting one, to be honest. So this is regarding email attachments not being covered by legal privilege. So this has been confirmed by the court. So the case that this was confirmed in was the Frasers Group PLS, which was formerly Sports Direct International, the Financial Reporting Council Ltd. So they, if I'm correct, Peter, you probably know more about this, but they actually regulate or look into stuff that the accountants do. So the Supreme Council actually heard this case when the Frasers were actually trying to appeal, and basically wanted to appeal the fact that the High Court and the Court of Appeal actually decided to disclose 21 email attachments. So the company bringing the appeal argued that because the email attachments were part of the email and that email is a privileged communication method, that the email attachment should also be included in that. However, the situation has now been cleared up, and a spokesperson on this has said that sending reports or other documents which are privileged to representatives via privileged communications does not mean that the reports themselves become privileged just because they are provided with correspondence which is protected. So I think that's Indeed. Just a key important thing to remember there.
Yeah, I mean, I think you're right, Laura. This is a fascinating one because making it clear that I think sometimes when it comes to both dealing with we're dealing with disclosure during the course of litigation, where you've got to decide what information are we going to disclose to the court and the other side. I think sometimes there is a temptation to go, oh, well, we'll keep this information back because it's legally privileged. And sometimes that has now been stretched to say, oh, well, just because this document was attached to an email and we exchanged it with our legal advisors, that means this document is now privileged. And in essence here, the court is saying, no, that is not the case. Just because it has been discussed in the course of communications with a lawyer doesn't mean it's actually privileged. And therefore, it is still, you've got to apply the disclosure test in its own right. By the same token, hypothetically, if you were dealing with a data protection subject access request or a Freedom of Information Act request, you can hold back. You can usually use legal professional privilege as a reason not to disclose information under both of those mechanisms. Yet this is saying, well, actually, no, just because it was in the course of those discussions with a lawyer doesn't mean you shouldn't be disclosing this as a result of a subject access request or a Freedom of Information Act request. So this judgment has significant implications, therefore, when it comes to disclosure and handling those sorts of requests, and it therefore means that those who handle those sorts of requests regularly are going to have to look at some of perhaps the training and the way they handle their systems to make sure that they aren't applying that legal professional privilege exemption more broadly than they otherwise should be. I suppose the other thing to note here as well is Sports Direct, now the Frasers Group. That's the company that is owned and run by Mike Ashley, who has been involved for many years as the owner of Newcastle United Football Club. And also, he has occasionally been criticised for some of the working practices in his stores. So when the lockdown was announced last year, the first one, he tried to argue that Sports Direct was an essential shop and had to stay open. So the idea is it would have to stay open so it could flog you things like cheap socks, because obviously that is an essential item in the time of a global pandemic. That didn't last very long, but it meant that that they did have to close, but people tended to remember that sort of example of sharp practice. The other thing is that in some of his warehouses, I think it's being compared to a sort of Victorian workhouse, some of the conditions that they tend to run their warehouses in, at the same time not sort of paying their staff an awful lot more than the national minimum wage either. So along with those sorts of sharp practices, it's kind of bundled in with that perhaps they've been trying to apply that legal professional privilege protection a little bit further than they otherwise would have done. So I just found it quite interesting that that was the group that had been involved in this case. But in the meantime, they seem to be doing very, very well. They're looking, I think, at buying Debenhams next, so I'm sure it won't have massive impact on Mr. Ashley's business interest.
I'd say hopefully not, but so moving on to the next one then. So this is regarding, so this is something that's going on in regards to the pandemic, like Peter mentioned earlier. So this is some malware that has been found on laptops given out by the government. I've accidentally left in a slide from one of our previous podcasts here. Just a little error of my part. But basically what has happened here, there's been some malware found on some laptops that have been given out by the government to children who are in the more vulnerable category. Maybe the parents don't have enough money to buy them a laptop and everything. They've been given out these laptops to help them with their schoolwork while they're doing it from home. And then the teachers of a school in Bradford were actually doing some checks on these laptops and found that there was some malware on there that was actually sending information back to Russia. So basically this has been reported to the Department of Education, and they have said they're looking into it. But like me and Peter was talking about this earlier, and it is very concerning to think that schools do have an additional safeguarding in place for children, and obviously the government needs to apply to that as well. Yet there hasn't been proper checks carried out on these laptops before they have been sent out to the children.
Indeed, thanks. I mean, I think this is it's not a great story for the government, unfortunately. I think I think people as a whole, just if we're looking at the pandemic as a whole, people are willing to cut the British government, I think, a fair amount of slack, generally thinking, well, who else, you know, they never expected to have to deal with this. Everything from procuring PPE to handling test and trace have been challenges thrown at the government, and they've been found wanting, but people are willing to sort of give them the benefit of the doubt. But I think where they've been very vulnerable in 2020 was in the way that the schools were closed, and then they stayed closed, and then the mess over school examinations impacts the life chances for a whole future generation that is going to be very heavily impacted by growing up and trying to find a job in the post-COVID world and the post-COVID economy anyway. So in the context of that, to then have to jump into the lockdown that we currently find ourselves in, where when it was announced, the Department of Education said, right, we're going to literally throw all these laptops out to children that don't have access to the equipment they need so they can work from home. It was almost, regrettably, you almost knew there was going to be a problem. And I was actually listening to a podcast from Professor Robert Winston, who listeners may be familiar with his program Child of Our Time. So he's done a lot of research on children, childhood behaviour as they grow up. And he was saying that at Imperial College, where he works, they've done a lot of work around, you know, use of laptops and handing them out. And he was actually quite surprised that the government hadn't sort of asked for help when it comes to distributing huge amounts of hardware and making sure there isn't ransomware or anything else potentially wrong with the kit. Let's not forget, this isn't just a matter of saying, right, you know, here's a boxed new Dell laptop, get on with it. Someone at the school has probably opened it up, had to set up the equipment, put on word processors and software and make sure if it's going to be used for video conferencing that that's on there and that it works. All that sort of stuff all had to be done. So it does then beg the question, what antivirus and anti-malware kit are you putting onto the device, if any? Are you potentially using apps that are unsuitable for use by children? Remembering that in the UK, definition of a child is a minor child under the age of 13. So potentially got quite young children on this. We've also got the fact that this is educational establishments and students. So that issue of safeguarding even applies in the field of adult education. I mean, Laura, you're an apprentice solicitor, and so you spend part of your week with BPP Law School, and they have safeguarding that they have to be mindful of, even though all their students, of course, have finished their A-levels and are adults who are then engaging in further education and further study. So when you think of all the red tape that universities and schools have to comply with when it comes to looking after their students to make sure that they aren't that they're receiving the right sort of content and the right levels of protection, to then throw out all of this kit and potentially expose them to, like you just said, malware from Russia. You know, you'd want to make sure that if you've got kids who are using video conferencing systems, that they are secure, that they are not potentially open to horrific things like grooming, or that, you know, the Bluetooth connections work and you've not got people who can potentially use a Bluetooth device to pair with the laptop and talk to the child. This might sound far-fetched, but it happens. Bluetooth devices have been compromised like that. It's been research has shown it, and therefore, when you're throwing out, you know, a couple £100 worth of very advanced kit at children, you want to make sure it's safe. And the fact that it hasn't been, I think, it's been an embarrassing week for the government when this came out, but actually because there's so many stories at the moment around the pandemic and politics and free speech and everything else, well, it's kind of been taken off the front page. In a normal time, this would have been a major issue and a major embarrassment for the government, and we haven't seen the last of it because they'll find other things probably on these laptops and problems with regards to them being compromised that won't be immediately apparent now, but probably will become apparent in the future weeks and months.
Yeah, absolutely. I think, like you mentioned, as sad as it is, it's kind of expected now that things that are rolled out this quickly during this pandemic have kind of gone wrong. Like the NHS app rolled out quickly, and that doesn't seem to have worked in any way, or not from the research I've seen anyway. So things like this, I think that the government just needs to step back and think about things a bit more, and maybe delegate their issues, their obligations, like you've said, get the company to help them, like you was talking about in your podcast that you were listening to.
Indeed, I mean, it's unfortunately the British government's winning touch with technology strikes again. There are very few government IT projects we can point to that come in on time and under budget and don't have something wrong with them. And unfortunately, this is another one that has been compromised.
Moving on to the next one then, I've put the right stuff on here this time. So this is in regards to the SRA blitz continuing on firms breaching their transparency rules. So since December in 2018, firms have actually had to publish price and service information on certain services on their websites, as well as detail avenues of complaint. So if everyone's got an issue, knowing where they can complain to, who they complain to, and like how they can do that as well. And then a year later, so in 2019, it became a requirement to add the SRA's badge, digital badge on their website as well. So this is just basically a reminder that the SRA are continuing to clamp down on these transparency rules. They have actually issued another 3 sanctions. This brings the total up to 9 since the beginning of the year, and we're only 22 days in. So the SRA have actually published the details of the penalties, and they're ranging from a rebuke to £2,000 fine after 2 years or more years of actually giving warnings about this, and then people are still failing to comply.
Indeed. So I think this story really is a big reminder of the fact that, as far as law firms are concerned, they do need to continue to be mindful of the fact that you need to have websites that are, law firm websites are more highly regulated than if you are a non-law firm. And any organisation that has got a website should have things like terms of use, privacy, and cookie policies on there. But law firms also have to have this element of price transparency, and also the SRA digital badge. And the best part of 10,000 law firms in England and Wales, and sometimes we still come across some that don't have this information on it. And sometimes it's either not there, or it's just simply not as detailed as it needs to be. So this is a reminder just to say, don't think that if your firm is comfortably off the radar, that you don't have too much contact from the SRA. Do not presume that you are not going to potentially face investigation and sanction by the SRA for it. This is something that they are now starting to enforce, and clearly if they're producing that many penalties, they're clearly devoting a lot of resources internally to identifying, investigating, and then enforcing against different firms. So don't give the SRA an excuse to put you in their crosshairs.
Yeah, absolutely. And I'm sure I've seen on the SRA website, when this first came in, they have provided a list of the services that do need to be more transparent, because not all services have to be and prices have to be on your website, but there is a limited list to that as well.
There is, and sometimes I think actually it's almost beholden on firms to think, well, enter into the spirit of it. You might argue that, well, we don't do that type of real estate work, or we don't do that type of private client work. Well, that's as maybe, but the SRA is looking for you to show willing and show good practice. So it might even be a good idea just to, even if you don't do that sort of work, just to have a general indicator as to your pricing matrix. Better to have it on there than to not have it. Ultimately, are many people going to look at it? Who knows? But certainly, as far as the SRA are concerned, you're demonstrating good practice and compliance with the spirit of their regulations.
Yeah, absolutely. So moving on to the next one then. So this is in regards to Google and their threat to withdraw the search engine from Australia. So this has come after Australia are planning on introducing a world first law to make Google and Facebook and potentially other tech companies pay media outlets for their news content. So US firms have fought back as a result of this, and have made a threat to withdraw some of their services from Australia. So Australia is far from Google's largest market, but obviously this would have an impact on Google if they did decide to withdraw this. So I think the article said as well that Australia have said that they're not going to back down to this threat, and are going to continue on with the law.
Yeah, thanks, Laura. I mean, this has got a really interesting story because it does go to the heart of the fact that an awful lot of people now do say that they turn around and use Facebook as a source of news. So they'll see they'll see a headline, see something that someone else has shared in their Facebook feed, and that becomes the way that people consume their news, rather than having either a subscription to a newspaper, or buying a newspaper, or watching TV news from a recognized network. And so increasingly people consume their news through Facebook, and Australia's taking a lead here to say, well, let's actually, because you look at all the revenue there and advertising revenue that is now hoovered up by Google and Facebook, they're then saying, well, look, let's restore the balance here, and therefore have the media outlets being compensated for the use of the content that they are producing. Certainly those that end up doing it for free and end up not receiving any recompense. And I think it's interesting to put this in context with the wider moves towards regulation of tech giants, where we've got everything from the Digital Services Act and Digital Markets Act in draft form in the European Union, to the Competition and Markets Authority in the UK looking at taking further steps, and also the fact that there is litigation in multiple different states in the United States now against Facebook with regards to how it has behaved in terms of its previous takeovers of Instagram and WhatsApp. And indeed, I think there's a wider issue with regards to how some of the tech firms are behaving. So, for example, they took down recently, I think it was the Parler network that a few people had jumped to after certain individuals were blocked from sites like Twitter and Facebook. Certain groups jumped to say, well, we'll use Parler. But yet that was then banned from Amazon Web Services. It was then delisted from, its app was delisted from iTunes, the Apple Store, and from Google Play. And in effect, it's almost then sort of blacklisting these things. And when that happens uniformly across multiple platforms, is that the behavior of a cartel? Bearing in mind, of course, that cartels are banned under American competition law. So there are, big tech is facing a challenge in multiple markets here. Now, you could argue that Australia, as you quite rightly say, Laura, is a small market with a comparatively smaller population, albeit with a a population with a more disposable income than those of many countries. So it is a market that is potential to buy quite a bit compared to some countries. Albeit their government here is saying, well, actually, we are potentially going to be the first in the world to lead on this, and it will be interesting to see if other countries follow. There have been similar moves, I think, in France a few years ago, where they looked at doing something similar. And it will be interesting to see if anyone else decides to follow. I think the final thing to bear in mind is that where you get tech companies occasionally saying, well, we don't like this potential regulation, we might pull out of the market. I mean, that's a threat that Facebook have made about leaving the European Union because of their potential changes with regards to regulation. But it's a big threat to make. Would anyone actually do it? That would be the interesting thing. And arguably, if a network turns around and says, you know what, Australia is making it too difficult for us to do business there, would other tech companies follow? Would other countries potentially end up being treated the same way? I think we're almost looking for that sort of test case to happen where a tech company follows through on its threat to quit. Bearing in mind that really they are they're regulated in a very light touch manner compared to the amount of power that they have and compared to the level of regulation they have compared to anything like, the robber barons in the US at the end of the 19th century and everything from rail to electricity to steel to oil, where they had far less power and faced far more regulation. So, who ultimately is going to be the country that starts to really clamp down, and what would the effects of that be?
Yeah, absolutely. I think this will be something we'll follow, obviously in line with the Digital Services Act, like you was talking about as well.
Yeah, there's going to be a lot on that in the coming years while that moves towards becoming law across the European Union, and we will indeed keep you posted on that.
Yeah. So the final story today then is regarding cyber criminals who have published more than 4,000 stolen separate files. So this is some cyber criminals that stole thousands of digital files belonging to the environmental regulator SEPA and have published them on the internet. So the public body actually had about 1.2 gigabytes of data stolen from its digital service system, on Christmas Eve last year. So SEPA have had rejected a ransom demand for the attack, which claimed by the Conti ransomware group. So it said that the 4,000 files that were released contain things like contracts, strategy documents, and databases, and this data has now been put onto the dark web. So I think this just highlights here that when these ransomware groups actually do make the threat of pay us the money or we will release your data, they actually do mean it sometimes.
Absolutely right, Laura. When it comes to ransomware, yeah, they'll release the data. If they say they're going to delete it, they will delete it. Very often when usually when you pay them, they actually do turn around and release the data. So there is kind of an honour amongst thieves. Ransomware groups know that they have to, if anything, have that integrity. They have to carry through on their threats. Otherwise, people wouldn't pay ransoms. And they have to then provide encryption keys when people do pay the ransom so that they can continue to make money out of people. Sadly. But the point here is that the damage can be very, very great. And it's a reminder of the fact to always make sure that your systems are as secure as possible. And going back to that, we've got ransomware on here, we're looking at malware on the school laptops earlier on. This is a reminder to make sure that your devices and your hardware are properly secured and then regularly updated to try and reduce the possibilities that criminals can end up being successful when it comes to installing and utilizing ransomware in this way.
Yeah, absolutely. So that's everything we've got time for today. We just wanted to bring to your attention the special offer we still have on for our GDPR compliance manual for legal practices. So this is once again down from £195 to £99, so around 50% off. So I'll just pass over to Peter just to give you a little bit more information about the manual.
Yeah, this is our guide, which has it's chock full of forms and templates and checklists to give organisations plenty of help when it comes to working out what does good practice look like when it comes to complying with GDPR. GDPR, of course, is very good at saying this is the standard you need to be at, but it doesn't tell you how to get there. So this contains checklists and guides to try and help you to get a handle on looking after your data, and probably as important as ever in light of the changes that we're looking at in relation to data adequacy from Europe. Don't forget as well that even though the UK has left the EU, GDPR continues to apply with the UK GDPR. And also a final few bits of information as well. Laura's referenced there the panel discussion that I took part in with the Law Society of England and Wales. If you take a look at the digital law page on both LinkedIn and Facebook, you'll find a link to that recording and you can watch that on demand for free. And also I'm taking part in a panel discussion on Brexit for Clio case management in a couple of weeks' time. The link so that you can subscribe and register for free for that is also available on the same social media channels, or you can just search for Clio and register on their website. But if you're wanting to watch live and be able to submit some questions, that is an ideal format to do so. That isn't just really related to data, I should add. That event is looking at the implications of the UK departing from the EU as a whole. So it's looking at data, e-commerce, but also everything else from exports to how ham sandwiches being confiscated and everything else. So if you're really into that minutiae, love to welcome you to that event as well.
Thank you, Peter. So we just want to say thank you once again for everyone for listening. Just a reminder, this webinar is a weekly webinar and podcast, and is available to view as a webinar on our YouTube channel and website, and as a podcast on Spotify, on Apple, and all the other podcast channels as well. So we'll be back next week for another episode, but thank you once again for listening.